All right, guys, welcome to drones, license plate readers, and poll cameras. We have a lot to cover and not a lot of time to do it in. I try to keep these webinars in about an hour or so. Afterwards, we're also going to do a search and seizure show. That means I'm going to answer your questions live. I don't care what the question is. First Amendment, Second Amendment, Fourth Amendment, Fifth Amendment, even Sixth Amendment. Hell, we can even talk about cruel and unusual punishment if you want. I'll talk to you about what you do in the bedroom. I don't care. We'll talk about anything you guys want to. Let's talk about it. So, for those who are watching on demand, please also know that we have hundreds and hundreds of people tuning in right now live, and they are going to do their comments. So when I look over to my left and your right, I guess, I'm going to be looking at the comments to see if there's anything that I can answer and so forth. And with that, let's kind of get into this. All right, some quick disclaimers. First of all, laws and agency standard operating procedures may be more restrictive. What I mean by that is I'm going to talk to you about the Fourth Amendment, federal law, best practices. I will talk to you about some state examples, and so forth. Just kind of give you some context. But just remember that many states are more restricted. Let me just give you an example. I'm broadcasting from Nevada right now. Nevada has the most restrictive drone law in America. And I don't get into specifically Nevada law because this is not a Nevada class. This is a general class. If you have any doubts about what you're doing out there, push the chain. And finally, this webinar is legal education, not legal advice. I'm sure that most of you have a legal advisor, and I hope, and in fact, I know that some of them are actually here. So let me just teach them too what I think the law is, and then, but at the end of the day, they make the decision. They're your legal advisor. With that, let's get out with those disclaimers out of the way. We're going to talk about drones, obviously LPRs, poll cameras in that order. Let's first talk about drones. And for those who have just joined us, please, if you have not sent your agency in your state, if it's not clear, right, who you work for and what state you're in, please send that in the chat. We want to make sure that everybody is represented proudly today. So, guys, the first rule that we have to talk about when you're talking about drones is, what's up, Josh? Is that you just realize that what people show to the public, right? What they expose to the public is not protected under the Constitution. There is no right of privacy for what is in plain view. You guys know that. Right to be, right to see. And that's the main rule that's really going to apply to drones. And so when a defendant says, your drone saw a stolen car in my backyard, the question is really fundamentally should be, was the drone lawfully present? That's under the Fourth Amendment. So let's go through some cases. I think the seminal case that you have to kind of appreciate here is Katz versus United States. In a nutshell, what happened here is that Katz was a bookie engaged in illegal gambling across state lines in like the 1960s. Okay, so the FBI had nothing better to do than to go after Katz for his victimless crime here. And they put a tape recorder on top of his phone booth, okay? And while he was talking to his compatriots in he was in LA, and he was talking to his compatriots and his accomplices in Miami and Boston. Well, they picked up his side of the conversation, and based on this one side of the conversation plus some other investigative techniques, this was enough to indict him, convict him, and we are going to the U.S. Supreme Court. Now, the reason why this case is seminal is because the federal government was arguing, hey, there is no constitutional issue here. There's no Fourth Amendment issue here because we never entered the phone booth while Charles Katz was in it. In other words, there's no trespass into the phone booth. The U.S. Supreme Court in the 1960s, the same court that gave us Miranda and some other, fringe cases, said, look, the problem here is that there is a right of privacy in the Fourth Amendment, right? And I understand it, but smarter people than me, like Anthony Scalia, didn't ever buy that. He said, "Hey, look, at the end of the day, where's the word privacy in the Fourth Amendment?" But our Supreme Court in 1967 said, "Look, there is a right of privacy." And what the government did here is they invaded a right of privacy when they put the tape recorder on top of the phone booth. Now, I don't like what the government did there. So, I don't like whether the means or the ends justify this, but the point is, this case is what's going to establish whether or not the drone is actually implicating the Fourth Amendment. It's very important for you to know this, okay? There are two searches under the Fourth Amendment. There's trespass and there's privacy, okay? And trespass is not going to be an issue here. We'll talk about some trespass cases, but generally speaking, the drone is not necessarily trespassing in the person's airspace. They don't own the airspace. They don't own anything above the. You don't own anything, but they don't have any property interest in anything that's not usable, right, for them. And so when that drone is up to 400 feet, and especially when it's not over their curtilage, the defendant simply does not have a trespass argument against the police. Hear me loud and clear. If that drone is over, is especially if it's over like open fields or it's open public land or whatever, and it's looking around, the defendant is not going to be able to make a trespass argument because that is not his usable airspace. I don't talk about usable airspace in this class because it's only a webinar, but I do talk about my full day class. But the point is, he or she's going to make a privacy argument. And in order to make a successful privacy argument, you have to prove two things. Number one, did the suspect expect privacy? Did he or she do those things that are necessary to kind of keep your stuff private, right? Did you build a really big wall around your backyard and really subjectively expecting that nobody's going to look inside your backyard, right? Also, is what you are expecting objectively reasonable? I can, my neighbor, can be out, and do, and taking, sun tanning and so forth, nude, right? But if she has, and I hope it's not a he, but if she has a 4-foot fence around her backyard, she may think that nobody's going to look. But I'm sorry, there are going to be people, depends on what my neighbor looks like, but a lot of people are going to look. Why? Because, and it's not going to violate privacy. She's the one that's not expecting, she should not expect privacy. It's not objectively reasonable. Both are required, okay? So did the suspect expect privacy? Would society consider it reasonable, right? A lot of people want to keep their stuff private, but it's not reasonable. Let me just give you a great example. A lot of criminals love, and when I say love, it's all capital letters. They love showing off their Glock switch, right? On social media. I never show off my Glock switch on social media because it's dumb, right? It's absolutely dumb. And when people show it off on social media, do they really hope only their friends see it? Sure they do. But when the police see it and they use it for a warrant, they don't have any privacy interest, right? So both are required. Now, how does this test apply to aerial surveillance? Let's walk through it, okay? Let's start off with U.S. versus Matthias. Now, Matthias is not a drone case. In fact, I got to tell you, only a couple of cases in this presentation today are about drones. Why? Because the courts are at least a decade behind technology, at least a decade, if not more, right? So you don't see a lot of drone cases because it takes so many years to work its way through the system. But we can use other cases for principles. This case, what happened here is an officer was in open fields and he went up to this fence. The fence was part of the backyard. It was part of curtilage. Curtilage is not spoiled cottage cheese. It is that area around a home that is treated like the home itself, right? And so that, and that's, you got to be very careful when you're on curtilage. So the officer was on open fields, which is not curtilage, looked over a fence because the fence, he didn't do a pull up on the fence. He just looked over the fence and he saw marijuana growing in plain view. Now, this is not a drone case, but it's drone-esque. It's drone-ish, right? In other words, the defendant's like, well, you looked over my fence. You looked in my backyard. You violated my reasonable expectation of privacy. And with those facts, did the officer violate the expectation of privacy? And the answer is no, right? So as the court said, the strip of land was an open field, not curtilage, and thus not protected by the Fourth Amendment. The officer's observations did not violate the defendant's reasonable expectation of privacy. So we now turn to the fence. The presence of the fence is sufficient to establish that Matthias manifested a subjective expectation of privacy in the backyard. Remember, in order to have privacy, you need two factors. Number one, did you expect it? Number two, was your expectation objectively reasonable? Accordingly, the only remaining question is whether society would recognize the expectation as reasonable. We conclude it would not. The mere fact that an individual has taken measures to restrict some views of his activities does not preclude an officer's observations from a public vantage point where he has a right to be and which renders the activities clearly visible. And so right to be, right to see. At the end of the day, the area, and so if somebody's asking, hey, does it matter who owns the open field? The answer is no, not under the Fourth Amendment, okay? It may matter in some states, like I would be careful in Tennessee, I would be careful in Texas, but generally speaking, the answer is no, right? Because open fields are just not protected. So when I say right to be, right to see, right to be under the Fourth Amendment, the answer is no. So this is a good kind of segue into like the drones, right? So the point here is that views from the ground with the naked eye are not searches unless there's a constitutional intrusion first. If the cop would have done a pull up onto the fence, that's probably problematic. If you would have been on the curtilage, problematic, and so forth. Let's now turn to Arno. Now, Arno is a 1979 case. Fine, it's an oldie but a goodie. Okay, what happened here was officers in California, they got into a helicopter and, I'm sorry. They didn't get into a helicopter. This is not Arno. So that's Sneed. So what happened in Arno is actually Arno is a very famous case involving the Playboy building. Okay, so in the 1970s, 60s, 70s, when Playboy, was at its zenith, a lot of states considered it pornography. Okay, so or illegal pornography. So indecent, right? So what happened here is an officer with binoculars, okay? He went to this hilltop about 200 to 300 yards away from the Playboy business office. Now, the key for you to understand, this is very important for drones, okay? For my drone pilots out there, is that if you want to make good case law here, the key here is that there was just no way that the human eye could have seen the indecent material from any lawful vantage point, okay? The office was high up. It was in an office building. It wasn't on the ground floor where people passing by the sidewalk could see it. The only way that these officers could see it and to see the indecent pornography in plain view is with binoculars. So, are we good here, right? Are we good? And the answer is going to be no, right? It's not plain view. It's not plain view. Seth is mad that he's the only one that answered. He should have been like, he's like, I should have just, nobody else answered. And I fell for it. But the point is, the problem is that this was an intrusion. Because now the first thing is, would Arno, right, and his compatriots, and his accomplices, would he expect privacy in his office building? Sure, he would. And would society also protect that? Yes, right? And it's crossing that line. There is a binocular rule, and that's what this binocular rule is that you can see something if you can see it in plain view, but they couldn't see it in plain view. Let's look at what Bryce said. He said the officer's intent on viewing was incorrect. A reasonable person would not be able to see it. That's correct. That's correct. Now, can the officer see something with unaided vision? And the answer is going to be yes, right? Okay. Yeah. Yeah, we're gonna talk about the 1,000-foot case is actually coming up. That is Ceriolo. So if the purpose, listen to what Arno said, okay? This is very, very important, okay? Very important. So if the purpose, thanks, Bryce. Got it. If the purpose of the optically aided view is to permit clandestine police surveillance of that which could be seen from a more obvious vantage point without the optical aid. There is no constitutional intrusion. Listen to what the court said, right? If you can see it without enhancement, then it's not a search. But if you can't even see it with the naked eye, and now you have to use, aided vision, and listen to me carefully, and that area you're looking into is an area of privacy. Think bedrooms, think think bedrooms, think not cars in public, not park benches, offices, and so forth. Then it can be a search. Okay, so Brian says, so the use of binoculars and telescopes during stakeouts looking into someone's house? No. The question first, Brian, is could you see the same thing? Could you see the same thing with unaided vision from a lawful vantage point? You're right. Does that make sense, Brian? In other words, could you be standing on that guy's sidewalk in front of his house and see the same thing? If the answer is yes, then you have no problem going down the street 200 yards and seeing the exact same thing with binoculars. Does that make sense? In other words, even if you are like, Your Honor, from 200 yards away, I cannot see it, but I could see it with my binoculars. That's not the question. The question is, at the time of the observation, could you have seen the same thing if you chose to stand in front of that guy's house from a lawful vantage point? If the answer is yes, it's not a search. Make sense, everybody? Make sense? Okay. So it's not about Carl. It's the common technology thing comes from a case called Kylo. I think it's a little bit overused, but the point is that's not the legal question. From right of privacy, just because it's something that's common doesn't necessarily mean that it won't invade a right of privacy. So we'll talk about that, I guess, a little bit more. Okay, night vision. Night vision, again, Rick, somebody put my book, my Search and Seizure book, in a link here because I answer all these questions in my Search and Seizure book. Okay. And I'm not saying that you need to buy it to get my answer. I'm just saying if you really want to be ahead of the game here, go check out the book. Okay. So night vision, here's the deal. If the night vision amplifies ambient lighting, it is not a search under the Fourth Amendment. Okay, so night vision. But if it's thermal imaging and it's pointed towards a house, it is a search under the Fourth Amendment. Does that make sense? So unless you have some really mad, superhero abilities and so forth, you cannot see heat. Okay, well, I guess there's some extreme cases, but you cannot see heat. So therefore, you don't have a thermal imager built into your eyeballs. Therefore, it's not plain view. And so, does the thermal imaging give you private information into the house? The answer is yes. That is why it's ambient lighting is ambient. Night vision. Literally, night vision is not a search, but thermal imaging on a home can be a search. But thermal imaging on cars, park benches, open fields would not be a search anyway. Okay. What about optical aids? Well, this is uh-oh. Hold on, I'm having mouse issues. Did my mouse go dead? Okay, looks like my mouse might have gone dead. Okay. Yeah, the mouse died. That's gonna be a little bit of a problem. We'll have to figure it out though. Actually, let me see if I can charge it real quick. Okay. So if the purpose of the optical aid is to view that which cannot be seen without it, then that's a Fourth Amendment search. Remember what I just told you, right? Standing in the guy's driveway, or I'm sorry, not driveway, but his sidewalk versus, you can never see it like an Arno where they had to go to a hilltop. Okay, the next thing is Seriolo. Seriolo is our 1,000-foot case. Let me see this. Seth said, I was remembering back to the webinar where the guy went off the cliff and used that like NASA telescope to look for drug deal. I'm not sure I know what that means, but so what happened in Seriolo is that the cops got into a airplane. They looked over a guy's backyard from like 1,000 feet. They saw marijuana plants growing in plain view. They used that observation to go get a search warrant, and then 73 plants were recovered. The Ceriolo is like, that is a violation of the Fourth Amendment, and the U.S. Supreme Court said, no, it was not, right? The observations by the officers in this case took place within public naval airspace in a physically non-intrusive manner. From the point where hold on one second, from this point, they were able to observe plants readily discernible to the naked eye. There it is, the naked eye, unaided vision is going to play a key with all these cases. The defendant's expectation that his garden was protected from such observation is unreasonable and is not an expectation that society is prepared to honor. All right, what do you? Keyboard, I guess. Yeah, I'm also charging it. All right, cool. Thank you. All right. Okay. So Bryce says, I have seen officers use their phones and zoom in and get a clearer view. Would that be of houses? Yes, that's fine. No issue. As long as what they're seeing is observable from the naked eye, unaided vision. Yes, you can use your glasses, okay, to get 20/20 vision. Then you're fine from a public place. Does that sound good, Bryce? Right? As long as your officers could see the same thing with unaided vision from a lawful vantage point, it's not a search under the Fourth Amendment. Okay, so the point here is that unintrusive, naked eye observations from naval airspace is not a search. You're welcome, my friend. Okay, now let's talk about the Snead case. What happened here is, okay, I'll explain a little bit in a second, Robert. So what happened here is officers got into a helicopter and hovered over this guy's backyard, like between 20 to like 25 feet above the ground, and above this corral, right? And this is going to be a problem, okay? It's a problem on many levels. It's not safe, probably, but at the end of the day, though, the problem is that even if it's not even over curtilage, even if it's over, well, I got to be careful with the open field stuff, but it's just so intrusive, right? It's so intrusive that the court is not going to uphold this, right? They said that while appellants certainly had no reasonable expectation of privacy from airplanes and helicopters flying at legal and reasonable heights, we have concluded that he did have a reasonable expectation of privacy to be free from noisy police observation by helicopter from the air at 20 to 25 feet, and that such an invasion was an unreasonable government intrusion into the serenity and privacy of his backyard. I think that just makes sense, right? Okay, now, Robert, how is naked eye and a division? Okay. So let me just kind of hopefully simplify this, right? And okay, so first of all, we have to just make sure we're talking about private spaces. We're talking about homes. We're talking about private offices. We are not talking about motor vehicles. We're not talking about Burger King, and we're not talking about park benches. We're talking about looking into areas where a person does have REP, reasonable expectation of privacy. Next, if you are going to use naked eye observations, fine. The question is, are you lawfully present? The motto is right to be, right to see. So far, so good. Next is, if you want to be clandestine, if you want to be surreptitious, if you want to hide, the next question is, you're probably going to be using aided vision, binoculars, night vision, and so forth. Fine. The next question is, you can use it to see into those private areas as long as what you are looking at was observable from a lawful vantage point. So in court, if I ask you, officer, you were 200 yards from my client's house, the defendant's house, correct? And you looked into his window or his backyard and you saw a kilo of cocaine. That's correct. Could you see, if you put the binoculars down, could you see in the backyard or and see on top of the kitchen table through the window? No, I could not. Okay. So then he's going to make the argument that that was a violation of expectation of privacy. Then the prosecutor gets up and says, okay, officer, was there an area that night around the house that you could stand and see the exact same thing with unaided vision? Yes. Where is that area? On the sidewalk, right in front of the window. There was nothing blocking your view? No, there was not. Then the judge will say, if he or she understands the law, not a search under the Fourth Amendment. Does that make sense? Versus Arno, which is on the hilltop, that could never have been seen with the naked vision. Okay. So, let's continue. Vogel. So, and then please give me some feedback, Brian and Robert, if I helped there. Hopefully I did. I'm trying to, hopefully break this down, but I know there's some innuendos. So what happened in Vogel was that an officer who was doing routine patrol in a Cessna. Okay, cool. Routine patrol in a Cessna took off and saw what he believed to be a marijuana plant in somebody's window. Okay. Well, he finishes his line patrol. He does his patrol. This is in South Dakota, so more cows than people, right? So he lands, and then the next day, when he's about to take off again to do his job, he brings binoculars. Now he takes binoculars and he evaluates the item more closely and confirms that, yes, what he saw yesterday was a marijuana plant. Are we good? Yes or no? Are we good? Y or N? Okay. Okay, good. The answer is yes. So, as the court said, if, for example, a person places a marijuana plant directly on his window sill so that it is observable from the street, his expectation of privacy concerning the plant is not significantly different from that in the case described above, where the plant was on the sun deck, and thus it is no search to scrutinize the plant with binoculars. I really think this helps, right? If you can see it with plain view, then it's not a search to examine it and look more closely at it with aided vision. Okay. So we're going to get the drones in a second. We're not done with drones. Hold on. So I'm going to answer your question, how all this applies to drones in a minute here. Okay. Brian says, how's that different from being on a hill? Because on the hill, there's no lawful place that the cop could have seen inside the window, inside the business. Does that make sense? The hill is the reason he got the vantage point to use the binoculars. But there was no sidewalk in front of the business that he could have seen the obscene materials. That makes sense? That's why there was no lawful place to have plain view. Right to be, right to see, with plain view, with unaided vision. I'm sorry, just unaided vision. That's why. All right, now we're going to rock your world a little bit with State versus McKelvey. So here's what happened. State troopers got in Alaska, they got a tip that McKelvey was growing, I guess, marijuana, and so forth. So they got into their plane and they used binoculars, high-powered binoculars, to scrutinize what was in his backyard. Now, with those observations, they got a warrant, and we went to now we're going to the Alaska Supreme Court. So he was also convicted of some weapons-related offenses too when they hit his house. So what the court said here, okay, they said peering into people's yards with a high-powered lens when flying overhead has a similar potential to reveal intimate details that a person may wish and expect to keep private. We hold that the Alaska Constitution, not the Fourth Amendment, they're not doing this under the Fourth Amendment, they're doing it under the Alaska Constitution, which is more restrictive than the Fourth Amendment. It's important for you to know that, but I still want to share this case. Okay, so we hold that under the Alaska Constitution, requires law enforcement officials to obtain a warrant before using aircraft and vision-enhancing technology, such as a camera with a zoom lens or binoculars, to observe the curtilage of a person's home that is protected from ground-level observation. Okay. I don't think that this case comes out the same way in California or Texas. I don't. because we have to go back to Arno, okay? And Arno is good law. What they're saying there is good law. We got to go back to Arno and ask this question. Can the troopers see the marijuana plants with unaided vision from a lawful position? In other words, could they have, not did they, listen to me, could they have flown that aircraft closer to that home lawfully and seen the same thing? If the answer is yes, it does not make a constitutional difference to move that aircraft a half a mile away and see the same thing with binoculars. Are you guys with me on this? However, is it more concerning for courts that we do business that way? It is what it is, okay? I'm just telling you that some courts don't like it, including Alaska. But they're doing it under Alaska Constitution, not the Fourth Amendment. I'm telling you right now that based on current case law, this case does not come out the same way in Fourth Amendment states like California, Texas, Nevada, and so forth. Well, Nevada is different because of a law. But anyway, the point is not under the Fourth Amendment. But the takeaway is this. Highly intrusive flying or using magnification to see something not visible from a lawful vantage point may be a search on the Fourth Amendment. And I do believe that, even though McKelvey is a little iffy under the Fourth Amendment. Okay? Okay. And Jameson, the answer is yes, correct. Now let's look at Dow Chemical versus United States. What happened here is that the EPA, for whatever reason, wanted to inspect Dow Chemical, a 2,000-acre plant in Pennsylvania in Michigan, without a warrant. Okay. Dow Chemical told them to beat it. Okay. They're not playing the games of the EPA. So the EPA then flew an airplane over the chemical plant and used the most sophisticated equipment available at that time to inspect the plant visually from the air. With this sophisticated equipment, they got a warrant and they took enforcement action. Are we good? And the answer is going to be yes. Here's why. We conclude that the open areas of an industrial plant complex with numerous plant structures spread over an area of 2,000 acres are not analogous to curtilage of a dwelling for the purposes of aerial surveillance. Therefore, Dow Chemical is vital for your training. Dow Chemical stands for the proposition that, open fields and chemical plants are just not curtilage. They don't have a right of privacy like the backyard of a home. Such an industrial complex, again, right, is more, comparable to an open field, and as such is open to the view and observation of persons in aircraft lawfully in a public airspace immediately above or sufficiently near the area for the reach of cameras. What is the takeaway? Highly intrusive searches of commercial property or open fields, even with high-tech equipment, are not searches. I said highly intrusive inspections, right? Not searches, because searches under the Fourth Amendment. So they're not Fourth Amendment searches. So far, so good. Okay. So now, but they did say this. Surveillance of private property. When they say private property, they're talking about homes, right, and curtilage, by using highly sophisticated surveillance equipment not generally available to the public might be constitutionally prescribed absent a warrant. So somebody brought this up earlier, and they talked about, this whole, exactly, Seth, right? They talked about stuff that's not in the general, you're fine. You're 1-to-1, Seth, okay? You're even at this point. So, this is just a warning that, you can cross a line. Where that line is, I'm gonna kind of give you some pro tips in a second here. So Charlie says, I presume Alaska has 2 constitutions, just as other states do, right? The state, right? And also the United States. Yes. I mean, that's one way to say it. In other words, the federal constitution obviously is the supreme law of the land, and Alaska can't go below that standard. They can't say, well, in Alaska, we only require reasonable suspicion to search cars under the motor vehicle exception. No, it's probable cause. But they can always make things more restrictive. So, for example, Washington, New Mexico, Pennsylvania, they require exigency to search cars with probable cause or a warrant. But that's not the law in California, Nevada, and so forth. Okay. Okay. So, how these cases apply to drones. Hopefully, my mouse will work. Come on, baby. All right. Oops. So, hold on one second, guys. Let me hey Rick, can you come back to the studio and see if we can get this other mouse hooked up? Why? So this drone video, which I can't play because my mouse has died and I thought it was charging, but it's not. So the point is that this video was about a COVID-19 drone. And it was, basically measuring people's temperature and so forth. And it was somewhat intrusive, if that's why I showed it. But there was also other things that the drone was seeing in plain view. Michael says, what if you were having a large drug problem in an employee parking lot, using and selling? Absolutely, you can use the drone for that. Because remember, the first question is even if you have a search or seizure, does this area have a reasonable expectation of privacy? If the answer is no, then it's not a search at all. You can be intrusive. Does that make sense? That's Dow Chemical. That's not a search in the Fourth Amendment. So Brian says, in many states, the state law is what significantly restricts use of drones. That is absolutely true. In fact, that's why I said Nevada has the most restrictive law. Utah has laws. Illinois, California doesn't really have that much paparazzi laws. But the point is, a lot of states. Okay, hey, I'm gonna lose the camera for a second, but I'm gonna keep on talking. So a lot of states have basically made up for the lack of court. I have a mouse. All right, hold on, guys. Let me just. Sorry about the technical difficulties. Hold on, guys. Okay, we're back in business. So because the courts are like a decade behind this drone issue, a lot of states have chosen to basically implement their own restrictions on their own. That makes sense? That's exactly what Brian is saying. Okay, let's see if we can watch this video.
In the small town of Westport, Connecticut, a drone is scanning for COVID-19 symptoms. And the reaction here is, well, mixed. Police have been flying drones here since 2016 for everything from traffic management to search and rescue. And they can use them to spot and warn people who are gathered too closely. But now, Dragonfly, the company that makes the drones, claims they can also detect whether you're running a fever, sneezing, or coughing heavily, all through a single camera flying 40 feet overhead.
Subtle differences are on like a millimeter type of basis. So if somebody's coughing, like this or like this, it's actually quite a different type of cough actually that they're detecting.
The police chief says this partnership could help the town reopen, and they need every tool possible.
In a pandemic, we'll see the elevated temperatures, we'll see the increase in blood pressure, we'll see the flushed skin. So to have the technology available for future incidents, whether it be COVID related or something else that comes our way, I think we need to prepare for that.
This is the first time Americans have been scanned for symptoms in this way, and there are skeptics.
I don't know that this technology could distinguish between somebody with COVID-19 and somebody with influenza. I'm inclined to doubt it.
Not to mention that many infected people never exhibit obvious symptoms. And even if it does work, are we ready to be scanned from the air?
The involvement of the police makes me more worried about how this technology might have what we sometimes call function creep. in that it is used and designed for one purpose, but then it gets repurposed for other things.
Do you believe that we're going to have to strike some kind of necessary compromise with the desire for privacy in order to get out of this thing?
Public health has built into it the need sometimes to invade people's privacies.
The chief says it's all just research, but the police will see and save everything.
By no means will we single out an individual and say, hey, look, you look like your temperature is elevated.
Will you be hanging on to data that Dragonfly is collecting, or does that somehow go around you?
Any missions, so to speak, that we fly with our drones, we keep those records.
Look, I show the video because let's not abuse what we got going on here, right? There's obviously some lines we got, that we're going to cross, just socially, so it would not be socially acceptable. And people are talking about Maryland, Jameson and Maryland. Yeah, Maryland actually has a very big case involving, observing Baltimore, the whole city of Baltimore, almost on a 24/7 basis. I forget the name of the case, something of whatever it is. But all right. You see what Kenny just wrote? That's actually pretty funny. The thought of government drones buzzing overhead, monitoring the activity of law-abiding citizens, runs contrary to the notion of what it means to live in a free society. So, let's not ruin it. Now, there it is. It's the leaders of a beautiful struggle. Exactly. Thank you, Brian. So, Long Lake Township. Here's what happened. Maxon has a lot of junk vehicles and junk in their backyard, okay? The Maxons. And so they agree to basically clean it up. They enter an agreement with the city or the township. So, but they don't comply. Then the township is now going to take a new enforcement action, and they hire a commercial operator, and they fly a drone over, listen to me carefully, over Maxon's backyard, okay? And they use this evidence for junk vehicles to take civil enforcement action. Now, the trial court found that this was a search under the Fourth Amendment. Flying that drone over their curtilage was a search under the Fourth Amendment. And here's my training point. I teach cops, really, like, if you're just trying to make some plain view observations, and you're not, you don't have exigency, you don't have a warrant, and so forth, don't fly over the curtilage, okay, guys? Don't fly over curtilage. If you fly over curtilage, you are introducing the argument that you're introducing that this is a Fourth Amendment search, okay? So I say what I teach here is fly off center, right? Off center the curtilage. Don't fly over open fields. Ideally, fly over streets. And don't use a lot of magnification. That could get into this whole argument. Could you see the same thing from plain view, blah, blah, blah. But if you're just flying over a street or an area where you're allowed to be, and you're not violating any state law, you're not violating Part 107, you're not being highly intrusive, okay? Then you should be fine under the Fourth Amendment. You guys with me on this? Now, ultimately, I want you guys to know, for my lawyers out there, that Maxon was eventually overturned on one main issue. The lower courts were applying the exclusionary rule, like, they said it was a Fourth Amendment search, but they were applying it to a civil issue. The problem is that the exclusionary rule does not apply to code enforcement. I mean, like civil issues. There might be a 1983 civil rights lawsuit. I'm not saying you can't get in trouble for this. I'm just saying the court does not apply the exclusionary rule to civil actions. Ultimately, this was civil, and so the observations came in. However, because the lower court still found that it was an unlawful search, the Maxons could sue Long Lake Township as a civil rights violation. So there's two different issues there. Okay, so Carl says, does curtilage extend upward into the into airspace, into the space? No, it does not. So I have another class on this, and basically curtilage is going to be your usable airspace, right? What can you use for the enjoyment? So where is that? You have to analyze it. Is it 50 feet? Is it 100 feet? Right? Is it 400 feet? Probably not. But however, here's my thing, right? So it's usable airspace. But that's the problem right there. because I cannot give you a certain a number of feet, then that way, therefore, I'm asking officers on the ground to make those judgments. Isn't it easier to just avoid this whole curtilage issue by flying off center? Do you agree? Yes or no? If you fly off center, they're not going to bring up a curtilage argument because they can't. Now, they'll say that you looked into my curtilage, but they can't say that you invaded my curtilage like they did in Maxon. So just stay. You don't really need to anyway. 99% of the time, the drone is going to see the same thing as that you would see off center. Now, some states like Nevada has a 200-foot rule. It's arbitrary and so forth. Brian says if you're off center, you have to use magnification. You gotta be careful about that. It is a double-edged sword. Absolutely. There's absolutely no definition of curtilage, vertical curtilage. Absolutely not. Okay. So let's continue. Okay, let's continue. So drones, so a lot of our case law comes from, well, it's Jose. I can tell you that I'm going way overboard on this class. So it was supposed to be an hour, but the questions, and there's a lot of people here, so I'm going to keep going, and I'm going to keep going. So it's if you guys want to stick around, please do. But let me just kind of wrap this up. A lot of our case law comes from exactly. Josh has 250 feet. Drones. A lot of our case law comes from human flights, helicopters, airplanes. But drones are not like helicopters. Okay, they're quiet and stealthy. They're cheap compared to helicopters. Don't take offense to this, but highly trained pilots are not the same. The same level of training is not required. I think we can agree on that. And if unchecked, millions of drones can be used by agencies around the country in just a few years. Okay. Now, what I do teach, generally speaking, is that if you're doing exactly what the public can do, you're abiding by all state and local laws, not being overly intrusive, and not using image enhancements, that is the best advice I have for you. Okay. Let's talk about license plate readers, okay? This is going to be an easy topic. License plate readers are not searches because there is no reasonable expectation of privacy in a license plate. And there's no reasonable expectation of privacy in the database that your registered information, okay? So instead, just as a conversation, let's just have a conversation and throw it out there. Can an LPR turn into a search? The answer is yes, under a mosaic theory. Let me just give you an example, okay, what I'm talking about here. So we have a case called Carpenter. Carpenter basically was that Carpenter was involved in, burglarizing, maybe even robbing, I think, some Metro PCS stores. So he was stealing cell phones. The FBI got his location information from his carrier. Okay, so they got 127 days of location information and used about 5 days of it in the prosecution against Carpenter. They put him at his location, put him at the cell phone store burglaries. So the Supreme Court said, look, this location information, okay, can repaint a picture of a person's life. They didn't call it the mosaic theory, but it was called that afterwards, okay? And basically, if you are able to piece together a person's life, and you get this piece of data, that piece of data, this piece of data, you're able to paint this picture. And look at what cell phones do today, right? Cell phones are their GPS tracking is way more specific and detailed, and minuscule movements and so forth compared to what it was just 15 years ago. So and also cell phone companies keep this data for 5 years. So if the federal government did not need a warrant and all they needed is a subpoena to just grab your location information without probable cause, right, just a subpoena, then they can no intimate details about you. How the hell does this have anything to do with LPRs? Why? Because LPRs, because LPRs can turn into a virtual GPS system. Let me give you an example, okay? So my hometown is Las Vegas. Las Vegas has cameras on practically every street light. It's a modern city. It's a very high tech city. And here's my point: there are companies out there that will sell software to the government that will turn these traffic cameras into LPRs. Okay, they will turn that. There's a company out of Texas, I believe, that has this software. And here's my opinion: if you do this, if your city does this, and you have the number of cameras that Las Vegas has, for example, and you also combine that software with Nest, where people like voluntarily give their cameras to the law enforcement, feeds to law enforcement, where you just have, whether it's now or 10 years from now or 20 years from now, if you have a government capability that they're just feeding all these cameras, and because of the software, reading the license plates or even doing AI vehicle recognition, right? That's able to track a vehicle around a city, then I do believe that at some point it's going to become a search. Why? Because it's just, it can give you kind of like, it's almost like a virtual GPS tracker. It's like a cell phone in your pocket in some ways. But the main case on here is McCarthy out of Massachusetts. Questions like, how many LPRs are there? Right now, there is no searching going on. There's not enough LPRs to cross this threshold, in my view. Okay, even if there's thousands, I know there's thousands of them out there, it's still not enough. How long will the information be retained? Are LPRs placed near constitutionally sensitive areas like churches and homes and political areas, and right? Campaign offices? Are they only used for emergencies, amber alerts, silver alerts, and so forth? And maybe the courts would uphold it, for those things. But at some point, they do become a search. While acknowledging the usefulness of these tools for crime detection, both this court and the United States Supreme Court have been careful to guard against the power of technology to shrink the realm of guaranteed privacy by emphasizing that privacy rights cannot be left at the mercy of advancing technology, but rather must be preserved and protected as new technologies are adopted and applied to law enforcement. That is a very good clue, okay? So, at the end of the day, you guys can download this PowerPoint if I skipped over something for time. But if LPRs are basically being used as a virtual GPS tracker and it has the capability to do that, then I think that you should be very careful. I think that you should have a policy about how long that information is retained, who's being tracked, is it general public or is it only sex offenders, parolees, etc. Right? All right. Now, if you have any questions, I'm going to take them during the Search and Seizure show at the end of the class. Okay. Now, again, when it comes to poll cameras, let's go back to what case? What is that seminal case that I told you about? That U.S. Supreme Court case from 1967. Does anybody remember that case? So we know that when you activity knowingly exposed to the public, it's cats, right? Activity knowingly exposed to the public is not protected because you do not have either a subjective expectation of privacy or you don't have objective expectation of privacy. Okay. Let's watch this video real quick.
And now cameras mounted on LP&L utility poles have some residents demanding answers. Several viewers took to our KCBD Facebook page asking questions about the cameras, so we went looking for some answers.
LP&L tells us they are part of a police surveillance program. KCBD News Channel 11 Sasha Wilson visited with those residents and joins us now with more. Sasha?
Karen and Abner, one of the two cameras we saw has an LPNL logo on it, which police say helps to disguise the equipment. They say LPNL is not the only city-owned business which mounts cameras for the police department across the hub city. I talked to one of the residents who voiced his concerns on Facebook. Jason Mendez has lived in this neighborhood for 20 years with his wife and 3 kids. He says he feels safe here.
For somebody to sit there and just watch and see what I'm doing, that's, like I said, you know, that's invading my privacy. It's very disrespectful. I don't really see anything in it, you know. If it's supposed to help the crime rate go down, then fine, but put it everywhere else. Put one on each corner of the block, not just on one corner and then the other one in an alley.
He says crime has happened around the outskirts of the neighborhood, but not where the cameras are pointed.
And some just said it's just to protect the neighborhoods. But from what I know, people in the neighborhood say that there's none in their areas. So why is it just gonna be on this block? There's not that much crime rate around here.
Let me tell you why it's on your block, because you are being surveilled, my friend. You are the target. If you found that camera pointed towards your house, you are the target. Now, now at the end of the day, poll cameras almost uniformly have been upheld by courts. Okay, a good example is this Moore Bush case. What happened here is that Moore Bush was thought to be involved in some kind of illegal firearm sales, and the government put a poll camera right about here, okay, on this poll camera right here. It was looking at her house for a very, very long period of time, and so the court found, the Supreme Court recognized that long-term tracking of a person's movements provides an intimate window into a person's life, revealing not only his particular movements, but through them, his familial, political, professional, religious, and sexual associations or lack thereof. So can a poll camera, can it kind of intrude into privacy? I got to tell you, I think at some point it does, right? I'm going to tell you what my thoughts are here. However, what happened here is at the lower court, okay, at the district court level, they found that this was like 8 months of warrantless poll camera. But the First Circuit reversed it. They said, look, where is the case law? Where do you see the U.S. Supreme Court saying that poll cameras are a search under the Fourth Amendment? And they were supposed to hear this entire case en banc, which means every First Circuit judge, but they never did. I don't know why, but it was scheduled for it, but it never happened, to my knowledge. So let's talk about Tafoya, though, okay? Hold on one second. I will, let me answer questions during the Search and Seizure show, if you don't mind, okay? So police surveilled this guy's front yard, backyard, driveway for more than 3 months. The camera mounted on a utility pole across the street from his property. Now, this was a Colorado case. So the court was asked whether the poll camera's 3-month recording of the suspect's house was a search under the what? The Fourth Amendment, not just the Colorado State Constitution. And what did they hold? They said, we acknowledge that by its own terms, the court's decision in Carpenter is a narrow one and does not call into question conventional surveillance techniques and tools such as security cameras. The reality is that society has come to accept a significant level of video surveillance. Security cameras are routinely installed in public parks, restaurants, stores, government buildings, schools, banks, gas stations, elevators, and all manner of public spaces. Additionally, security cameras are increasingly being installed on public streets, highways, and utility poles. A poll camera, however, is not a security camera by any stretch of the imagination. Law enforcement officers did not install the poll camera here to guard against crime, but to investigate suspects. Indeed, the prototypical security camera exists to monitor a heavily trafficked area of commercial establishment or commercial establishment. Security camera operators often install their cameras in plain view or with warning signs or even lights to deter wrongdoers. The government hid the poll camera out of sight of its target and does not suggest that it did so to prevent criminal activity. So, I want to tell you something, and I want you to know that if you disagree with me, we are still friends, okay? I do believe strongly that targeted, long-term 24/7 recording of a person's curtilage is a search under the Fourth Amendment. I repeat, I believe, if the U.S. Supreme Court took this case directly, and eventually they will, that if you have targeted, meaning I'm looking at your house, and it's long term. What's long term? 90 days. Let's just I'll give you a number. How about 90 days? Targeted, long term, 30 days or more, 90 days or more, but not 8 months. 24/7 recording of curtilage is a search under the Fourth Amendment. I have seen courts talk about how it's possible to put a police officer on top of the pole 24/7 for 8 months, and therefore that's why it's not a search. And I'm like, come on, right? I mean, I don't buy it. But I just want you guys to know that most courts disagree with me. Okay, most courts do not agree with me. Tuggle is your main case out there right now. They upheld 18 months of targeted long-term recording. And I got to tell you, I'm offended by it because I just don't see how that does not offend a person's reasonable expectation of privacy. Because if you can record a person's curtilage for 18 months, will you know a lot about them, their friends, their political associates, because you're going to get more information, you're going to get their license plates. Are you going to know their habits and maybe some of their secrets? You're going to see a lot of intimate details about that person that would not have been known, okay? Yes, I guess theoretically it is possible that you can put a cop on top of the pole that lives on a tent for 18 months straight and just put food up there with a pole, but it's not likely, okay? And it's not probable. It's kind of ridiculous, and I don't like it. But at the same time, the law is against me. So I just want to let you guys know that I think that that's where it's heading, and I'm pretty confident that one day when the U.S. Supreme Court takes up this issue, they are going to put some limits, just like they did in Carpenter. Okay, they said, look, that warrantless tracking of that guy through that third-party information, that was a search. I think they're going to say the same thing about poll cameras, but they're not going to say one day is a search. They're going to give us a number, and it's going to be 90 days or less, in my view. Now, the last thing I want to talk to you about is Scottsdale, this case out of Scottsdale. And what happened here is that they the DEA put a poll camera, very, very high-tech camera that was able to magnify and from very far away. They saw this guy doing drug deals in his apartment complex parking lot over a very long period of time. They used that information to indict him, convict him. Are we good, my friends? Are we good? Long-term, targeted, 24/7 recording of the parking lot. Are we good? Yes or no? Yes, 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 yes. You have to say yes. Why? You have to say yes. Because it's public. It's not a private area. You don't have any reasonable expectation of privacy in the parking lot. That's why I do not feel that this would ever be an issue, right? It's not going to be an issue. No. Even my cautiousness with the Fourth Amendment, this will never be an issue. It's going to be curtilage. It's not going to be a parking lot or a parking spot at an apartment complex. It's going to be the front yard or the backyard. The evidence points to the fact that a person would not be required to be a complex residence to come and going. By the way, I don't care about that. Even if the property had a gate, I'm sorry, I don't think it changes anything. But regardless, any expectation of privacy by defendant in the complex parking lot surveillance was unreasonable. Therefore, the law enforcement use of a poll camera did not violate the Fourth Amendment, and thus there is no need for law enforcement to seek a warrant before using the camera. A camera recording an area open to the public is rarely going to be a search. That's going to be Brooks. So right there, U.S. versus Brooks, 2012. Sorry about that. I went quick on it. You guys got it? And not you, Brooks. A different Brooks. Robert does not change anything for me. Robert says, even if you need permission to enter a gated facility, no. Does not change. Not generally speaking. Yes, That's another class that we can talk about it. But even these, generally speaking, you know, oh, here's Tuggle. So the apartment complex that have gated access, but there's like hundreds of people that live there. You know, it is what it is, right? You don't have enough privacy. However, there are cases out there where when you have only a few people, listen to me, when only you have a few people that have access to that area, think like a quadplex, right? So think like a quadplex where only 4 people live there, and only those 4 people have access to that backyard, right? Is that curtilage? No. Can it be an area of a reasonable expectation of privacy? Yes. However, that conversation is too complex for today's conversation. I have cases for that, but that's for another day. But the answer is that you have to be careful. But apartment complexes where the people park and there's like 100 units or 50 units, it's not gonna be that way. Here's the Tuggle case. The Tuggle case is going to be your most cited case on this issue, okay? Tuggle is what people are going to use against me and say, Anthony, I hear you, targeted, 24/7 recording of private areas, blah, 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 but you're dead wrong because Tuggle says you're wrong, and they are right. Defendant was indicted on charges of drug distribution. They surveilled his home with a poll camera for 18 months. 18 months. And they said it did not violate the Fourth Amendment. However, they did say, it wasn't like Tuggle said, oh, it's game on. Don't feel bad about it. Don't lose any sleep over it. It's never going to be an issue. They just said, look, we don't have any Supreme Court guidance here that tells us that this is a search, and they are correct, okay? But save your questions for the Search Seizure show. We're almost there. So takeaways. Number 1, drones. If you do exactly what the public can do and you're not flying over curtilage, which is not recommended, you should be just fine, okay? LPRs. There's no issue there unless they replicate GPS. Right now, I'm not aware of any use case where the LPRs replicate GPS. Poll cameras. If it records homes for a long time, I say get a warrant. Okay. So for those who are watching on demand, I appreciate you. If you have not attended a class live, I hope that you do. This topic, quite frankly, is a lot to try to take on in an hour, and we went over about 15 minutes or so. But I appreciate you guys. Please, you can download this video. You can use it for your agency. You can make it part of your training program. You do not need my permission. You have my permission. Use whatever you want and share with your friends. But for those who are watching on demand, I'm going to end the webinar now. I'm going to share, I'm going to do some trivia with my friends who are here. And I'm also going to record the Search and Seizure show starting in a few minutes. So thank you guys for being here, and stay safe.